I'm just going to very briefly introduce our respondents to the initial panel that we had so that we can give them a maximum amount of time. Let me just briefly describe the format. We'll have each of them talk for about 10 minutes, and then we should have about 15 minutes for your questions and comments. So on my immediate left is Sandy. Sandy, pronounce your last name for me. Fabritz. And Sandy is the director of the Arizona Division of Water Resources. She's been there for 20 years. Next to Sandy is Jeff Kightlinger. Jeff is the general manager of the Metropolitan Water District, and he's been there since 2006, I think he's been the general manager. And then finally, on his left, we have a person many of you know, Jim Lochhead, who is the head of Denver Water. I'm going to turn it over to them. Sandy, do you want to start?
Sure. Be happy to. Thank you very much, and thank you so much for the invitation to be here today. Beautiful facility, beautiful day, nice weather. Being from Phoenix, it's always nice to cool down just a tad, although 107 ain't that bad. But I appreciate the comments made earlier. It's really good to have folks who can make water interesting and make water entertaining, because otherwise we wouldn't get the attention that we need to get. And it helps, and I'm being serious, it really does help promote what we need to be looking at into the future. The hard part is, as we've looked into the past, and I'm a little pissed off because the AZV California is going to be 50. That means I'm going to be 50. So it's like, so it's a little eye-opening for me. I never thought I'd really ever hit this point in time, but here I am, and here we are. And I think that is really the important message that I have today. We're here because of things that have happened in the past. We're here because of decisions that have been made. We're here because of things that different states, different entities, court decisions, you name it, that's why we're here. And we're still operating, and we're going to continue to do that moving forward. The going back in time and looking at cases for somebody like me, I'm not an attorney. I'm an engineer, so it's a little more pragmatic for me. I have to look at how things actually work. But going back and looking at litigation and trying to determine were right decisions made or were wrong decisions made, I don't have that luxury right now. What we have to do as water managers is look forward and figure out how we're going to manage in the existing environment, under the existing legal structures, with the challenges that we have in front of us. And there's no doubt that we have challenges in front of us. I especially appreciate the comment Mr. Glennon made. I think, what did you call the cooperation? That's correct. It was great. It's been awesome. It's been perfect. It's been brilliant. The cooperation that has occurred within the basin over the last couple of decades is very different, obviously, than the litigation, sort of the attitude that prevailed before that. Arizona is obviously always going to be, or in the past has been, let's hope, our colorful past can make us oftentimes unique, or an object for humor. But broad characterizations oftentimes don't lead to cooperation. Not everybody in the state of Arizona was opposed to the compact. Not everybody in the state of Arizona was opposed to any elements of these. There were certain political situations going on at the time. But again, moving forward, what we have to look at are, where we've come from, but more importantly, where we're going to be going into the future. We have a history of success in our state for dealing with matters and facing them head on. The Salt River Project, one of the very first reclamation projects, is an example of that, where the farmers put their money together, put their land up as collateral to address a problem, a specific problem within that part of the state. There was either too much water or there wasn't enough water. You never could, couldn't really predict it. And so they came together and solved a problem. The Central Arizona Project, it took Arizona 50 years nearly to get that in place through AZV California, and I won't gloat that we won, I never would, because it wasn't really, it was a win, but we also sort of lost part of that in a subsequent act. It's kind of, it's an interesting history lesson. But, you know, coming together, solving that problem was an important element. The negotiations that have been done on the shortage sharing on the river, the negotiations that have been done and the collaboration that has been done on the passage of Minute 319, which was very recent. Very, very important, not only to the state of Arizona, but to the economy of the Southwest. The basin study, it wasn't a surprise. I think people are surprised that we say it wasn't a surprise, and we're often accused as water managers of burying our heads in the sand and doing nothing. Well, we haven't done nothing. We've been doing things. These collaborative processes are examples of that. Examples in Arizona are the Arizona Water Banking Authority, which was it was sort of a poke in the eye to California, but it's a real program. It's a real good program. We were putting water into the ground to protect ourselves against shortages, of which Arizona does have to take a shortage and California does not have to take a shortage. And so that's an example of, we had a situation, we have a legal strategy or a legal doctrine that we have to follow. We have to respond to that, and we have to move ahead and respond to that. Where there's 3.5 million acre feet in the ground from the Arizona Water Banking Authority, and then there's another 5 million acre feet that have been stored in Arizona aquifers by other entities, cities, towns, industries, people who are making decisions, economic decisions, based on these past legal principles, based on the existing law of the river, to protect their citizens, to protect their customers. And that's what we as water managers have to, that's our challenge, is protecting our customers and making sure water is delivered. I work for the state of Arizona, so my customers are very, very broad. They're not just municipal interests, they're agricultural interests, they're industrial interests, they're mining interests. And oftentimes we feel like in Arizona that we do get picked on a little bit because we have the audacity to live in an environment that is arid and be successful in doing that. I'm not sure, I think that's the American way. That's kind of how I was raised. But going back to some of those successes and following, and I'll wrap up here in just a second. She hasn't signaled me yet that I'm done, but I'm close, I know. Conservation, looking to the future, looking towards the outcomes of the basin study and the things that we need to do. Going back to collaboration, having all of us work together. We are committed, and I don't mean just Arizona, I think every basin state, all the water managers, all the attorneys, I believe we are committed to working together, working with the federal government, working with each other, trying to find real solutions. We have, out of the Colorado River Basin Project Act, Arizona was given, or the Central Arizona Project, while we got the project, we were given the lowest priority. But we were also told that augmentation would be an element of any future management. That was part of the deal that was cut. And so, yes, we can look at water conservation. Arizona has been very successful in water conservation. Our statewide water use in 1957 was approximately 7.5 million acre feet. It spiked up in 1980 to just over 10 million acre feet. And in 2010, Arizona's total water use was 7.5 million acre feet. So I believe in conservation. I believe we've implemented conservation, but how much more can we do? Those are things that we have to look at and the challenges that we face in our own state. But augmentation has the potential, and I mean real augmentation, has the potential to solve a lot of our problems. And so we will continue to look at that. We will have to continue to look at that and not look back and try to find out how we could change things, how we can change laws that are already on the books, laws that people have made investments as a result of. We basically will continue to move forward.
Okay. Well, thanks for not gloating, Sandy. I I actually want to spend a little time thinking back on the history, a little bit on the Arizona versus California, because that really is intertwined with Metropolitan Water District. Metropolitan Water District basically was created out of Colorado River issues. And so there's a little history there that's pretty fascinating. Let's see, this is October of this year. So October 9th, 2013 will be the 100th year anniversary of the first delivery of water from Owens Valley to the city of Los Angeles. And William Mulholland gave his 5-word speech. There it is, take it. That was when they turned on the aqueduct. So it's a pretty big moment in California history. But by 1920, the combined population of Los Angeles and the city of San Diego was a third larger in 1920 than the combined population of Nevada and Arizona. And so the Owens Valley supply that was supposed to last city of Los Angeles and the growing region of Los Angeles County, Orange County, that was supposed to basically do through 1950 was already seen by 1920 as already getting outstripped. And so Mulholland actually went off in horse and buggy to the Colorado River, sketched out one route. Then after that said, this is hard work. That's why I have, delegates, and sent his staff out to sketch out a couple more routes. Went into the city attorney's office and said, we need to go build an aqueduct to the Colorado River. And they priced it out, a little over $150 million in 1926 dollars. And decided they couldn't afford it as the city of LA. The assessed valuation wouldn't cover it. But they got the idea of if you brought in the suburbs, the cities of Pasadena, Glendale, Beverly Hills, Burbank, etc., you could do it. And that's how Metropolitan Water District was created. Went to the state legislature, Mulholland testified, they created MWD, and that's what we were created with a single mission of going to go build the Colorado River Aqueduct. And that's what we did. We started building in 1931, came online 1941, and we began delivering Colorado River water. And so that was Metropolitan's goal, and again, that was supposed to be all our planning, all our thinking was, we're pretty much done through about 2000. And by the mid-50s, after the World War II post-boom had taken place in Southern California, so just literally a decade later, we were already saying, we're running out of water. And that kicked off a huge debate in terms of Southern California. What should we be doing in terms of getting a new supply? And Governor Pat Brown came up with the idea of the State Water Project, going to move water from north to south, from the western Sierras, above the Delta, and bring it all down to the Central Valley, west side of the Central Valley, and the heart of the Central Valley in Kern County, and then over to the Tehachapi's into Southern California. Fascinating, the real glitch for us at the time was Arizona versus California had started. And our board was the key consideration for Metropolitan, since we felt our mission was the Colorado River, was this was going to undercut us in the court. If we agreed to go get another supply of water, we felt the Supreme Court would be looking at that going, Arizona doesn't have another supply, California's got something on track. And so we actually pushed back on Governor Pat Brown and said, we're not very interested in this project. He sent a couple of lawyers, Stan Cronick and Adolf Moskowitz out of Cronick Moskowitz, a renowned firm in Northern California. And you gotta love the state. This was the what we call in California, Brown Act era, before they had sunshine laws. So we had just a closed session negotiation with a couple of lawyers, our full board, and they came out and said, on second thought, that's a heck of a project. With our chairman dead set against it. Joe Jensen, our longtime chairman, dead set against the project. But the rest of the board, including City of LA, flipped on him after the discussions, whatever was said in there, and we decided to do it. A remarkable commitment, 75 years contract. So we entered it in 1960. It runs through 2035, and our commitment was we were going to pay half the cost of the entire development of the State Water Project, the most expensive project at its time ever developed. And we were going to pay for it every single year, half the cost of it, regardless of how much water we ever took, needed, or got. And at the time when we started, we didn't take very much. In fact, for 40 years, Metropolitan took less than its allowed allotment every year. It wasn't until 2000 that we really fully needed that. But that was the commitment, and we've been paying that ever since. Put it in perspective, it's 1/3 of our annual budget. Our current check to the state of California for our share of the state water project is about $600 million a year. So it's a pretty massive commitment by Southern California. That came online, and probably very grateful that we made that decision, because we made that decision in 1960, and then 63 Arizona versus California came out and caused a lot of thinking within Southern California. One of the great anecdotes I remember was my former boss was from the AG's office, was talking about how the day the decision came out, one AG, Charlie Corker, dashed off a memo, sent it to the entire Attorney General's office about how we really won if you really sifted through it. A guy named Gil Nelson, who'd always urged the governor and urged California to try to find a way to settle with Arizona, but Mike Ely was saying, we're not going to settle because we're going to win, dashed off a memo saying it would be far better if we just defaulted on the pleadings. We actually would have done slightly better. They proceeded to bombard each other with memos back and forth while everybody watched in amazement until Stanley Mosk, who went on to be the head of the California Supreme Court, sent out a memo that there will be no more memos on Arizona versus California. So it was obviously a tough issue for us at the time. But one of the realities was that decision, so 1963, we didn't lose really a drop of water. Metropolitan kept a full aqueduct through 2003. So for 40 years, we basically had a full aqueduct of Colorado River Aqueduct. It was a little bit of eye-opener. December 31, 2003, 2002, we got a memo from an email from Gail Norton saying, your aqueduct's cut in half starting January 1. So I think Bob Johnson probably is the one who actually sent that to us. So that was an eye-opener, but we knew it was coming. But for 40 years, we basically lived off Colorado River water, getting an extra 500,000 acre-feet above and beyond the California's 4.4. So all things considered, 40 years, probably not too bad. One of the real big challenges, though, came while we were living off that, and we were able to build the State Water Project and get that in line in the 1970s. Really came about by around 1990. If you really kind of looked at it, 1900, new water supply, 1930s, another new water supply, Colorado River, 1960s, State Water Project. Sure enough, we kept growing in Southern California. 1990s, we needed more water. It was the first time we actually rationed water in 1990s. In the 1970s drought, which was a very terrific drought in California, because we had a full Colorado River aqueduct, Metropolitan was in position to lend water to places like Marin or Santa Barbara that were really short. Didn't have that luxury in 1990. We actually rationed throughout Southern California. And it was a bit of an eye-opener. We dusted off some of the old plans to go to the Columbia River and the Klamath, but probably not going to build 4 or 5 nuclear power plants and lift it over there. But we still have the Parsons plan in our shelf. But those things, we don't have one for the Great Lakes, though. So, but I have seen the Columbia and the Klamath plans. But in any event, 1990s, we really got serious about how are we going to diversify and change how we get water. And was the first time we really came up with integrated resource plan, strategic targets on conservation. Pretty much every city in Southern California, encourage people to conserve, but we never really had targets. We implemented a thing called a public goods charge. On every drop of water Met sells, we sell 2 million acre-feet of water a year. On every acre-foot, we charge $42 an acre-foot for a public goods charge. That $80-some million it generates is all used for conservation, recycling, reclamation. We started implementing these things in 1990, and it's really helped us be where we are today. Where we are today, we import, Metropolitan sells about 25% less water in 2013 than we sold in 1990. And still a little bit under 2 million acre-feet. 1990 was our high water mark. We sold 2.5 million acre-feet. But we were 14 million people then, we're 19 million people today. So we've been able to do all that with conservation, recycling, reclamation. It's getting tighter, it's getting tougher, and it's also tougher in California. We are losing chunks of our state water project supply every year to endangered fish. We are willing to pony up our share of $24 billion for a couple of tunnels to just help improve the reliability of that supply. Governor Jerry Brown thinks it's a good idea. He also thought the Peripheral Canal was a good idea in 1982 when he was governor first time around. But that is going to be a tremendous challenge. But we are on track to move that project forward to a decision this spring of 14. And so that'll be a pretty momentous decision within California. So we are continuing to move projects, we are continuing to do that, but it's all within the concept of, and this is something that's a little tricky, that we are going to be flat. Our game plan at Metropolitan is we sold between 2 and 2.2 million acre feet of water a year in 1990. We're selling it today in 2013, and our game plan is to be doing that in 2035, and educating everybody that you're doing a heck of a job using less water, and our flat business model means we have to charge more and more for the same increment you get every single year. And it works as a public service. It's interesting as a business model, and keep explaining it. But that is where we are today. The last little bit on collaboration, I think, has been tremendous. The municipal agencies have really taken to reaching across state lines. Our relationship with the Central Arizona Project, Southern Nevada Water Authority, never been better. We're talking with Jim at Denver Water. I really think that the municipal agencies, sort of in many respects on the front line here, are reaching out and crossing state lines, and that has helped this last decade on the Colorado River to be a very collaborative decade. And we've seen, Bob Glenn will walk through all the agreements we've had. We've had a host of agreements. Probably the most important one for Met was the 2007 guidelines, where for us, it was less about the shortage sharing than it was about the Lake Mead banking, but that has allowed us to introduce so much flexibility into our system. And so with that, I'll turn over and get an upper basin perspective on things.
Sounds good. Well, of course, as a lawyer, I just can't let things go. I guess former lawyer. But I really appreciate Larry's and Robert's presentations. They really, I think, set the tone for the conference and frame the importance of the decree in Arizona versus California in a way that goes beyond just a lawsuit between Arizona and California, but really the foundation for a lot of the agreements that we're working on today. I want to offer kind of first off a very parochial Colorado view of some of the things that Larry and Robert talked about, but then transition to some broader things. I had offered to debate Sandy about the Gila River, but she didn't take me up on it, unfortunately. She didn't want to go there. So
there's no need to. It's not want.
Dang it.
There's no need.
It's no fun. But from Colorado's perspective, Arizona started suing California and really all 7 states starting in 1931, as was noted earlier, in various attempts to deal with Arizona's interpretation. Remember, the Arizona hadn't yet ratified the compact at that point. So they were working to try and get their version of the compact through litigation, and were unsuccessful in a number of attempts at joining the states until the 1963 case that started in the 1950s. And Larry alluded to the kind of strained interpretation of the Boulder Canyon Project Act that the special master in the Supreme Court did, and it's kind of fun reading for a lawyer to read those and look at how the special master in the court struggled with the wording of the Boulder Canyon Project Act, which has a very clear reference to the compact, and to essentially rewrite it into a way that says, no, Congress was really just intending to apportion main stem water. And I'm totally speculating here, but I'm just wondering if they had kind of put themselves in a box when they did that, because they really couldn't address the compact itself. And the reason was that starting through all those various decisions, Arizona had tried to join all 7 states into an interpretation of the Colorado River Compact and was unsuccessful. And ultimately, the only parties to the litigation were, of course, Arizona and California, but also Utah because of its Virgin River water that's tributary in the lower basin, and New Mexico because of its portion of the Gila River that's tributary in the lower basin. So Colorado and Wyoming weren't parties to the litigation. So the court really couldn't rule on any compact issue because all the parties to the compact weren't before the court. And so I think that they, as I say, I think that they kind of put, it was kind of in a box to say, okay, now we have this clear reference to the compact in the Boulder Canyon Project Act, but not all the parties are here, so we really can't talk about the compact, so we need to just convolute the Boulder Canyon Project Act to get the result that we want and get a resolution of the case. And so it's kind of an interesting result, and it obviously, that was the Supreme Court, so it is what it is. There's no appeal from there. I think that the result of the case, Larry described, and we all know the situation in the lower basin in particular in terms of the structural deficit that exists. There's, if you assume 8.23 million acre feet being released from Lake Powell, which Colorado wouldn't concede, and we'll get an argument of the Gila, there's 9 million acre feet coming into the lower basin. There's about 9.6 million acre feet being used in terms of Arizona, California, Nevada, Mexico, and transit losses. And there's about 600,000 acre feet of evaporation loss. So there's a 1.2 million acre foot deficit in the system, if you assume that consistent input of 8.23 million acre feet. So why does Colorado even care? We weren't parties to the lawsuit. It is what it is. We can just live within our compact, give the lower basin 8.23 million acre feet, and let them dry up and blow away. So that was my parochial Colorado view. Of course, that's not reality. Of course, that's not the way we've dealt with each other on the river. That's not the way we should deal with each other on the river. And from representing a utility that has half of our water supply based on Colorado River water, and which is also post-compact water, uncertainty, conflict, litigation, having the federal government come in and manage the river, which is a terrible thing unless they're bringing money, is something that is not in the interest of certainly of Denver Water or in the state of Colorado. So we do have a direct stake in working with the other basin states toward greater security, greater certainty, and better management of the system into the future. And in fact, as was pointed out in the basin study, these long-term deficits are not just the lower basin, but they're basin-wide deficits, and we need to deal with them as 7 states. The decree is extremely important beyond just resolving Arizona's stake in the river. It really sets a framework for secretarial accounting of what goes on in the river, and it really is the framework for all the agreements that the basin states have reached out and accomplished in the last several years. It specifically provides for an allocation of surplus water over and above 7.5 million acre feet, and that's what we dealt with in the negotiation of the 01 surplus guidelines that form the basis for the quantification settlement agreement in California that achieved a way for Metropolitan to secure its water supply within California's basic apportionment. That was extremely important for California. It was extremely important for Colorado and the upper basin to find ways to achieve certainty for Metropolitan within that basic apportionment. Normal water is allocated by the Secretary when there's just 7.5 million acre feet. That's basically the condition that we've been in since 2001. And then there's shortage, which is when there's less than 7.5 million acre feet. And the decree doesn't speak to what the Secretary's authorities are in the event of a shortage situation. What are the criteria that the Secretary really uses? There's some broad criteria in the decree, but it's not very specific. And the Secretary's never allocated a shortage. Also important in the decree is that each state has the right to use, in the lower basin, has the right to use water that's unused by other states, and that's the basis upon which Metropolitan for 40 years was able to have a full supply over and above California's apportionment because there was surplus, because there was unused water in Nevada and Arizona, until the brilliance of Arizona in creating the Arizona Water Bank, which kind of put the squeeze on the whole system. So that framework of accounting and management and delivery of water under the decree was the underpinning of the 01 surplus guidelines, is the underpinning of the shortage guidelines that are very carefully framed with using language in the decree. And through those negotiations, Arizona continually said the decree is very important to us. We have to have everything framed within the decree, and it is, as well as Minute 319. So looking forward, if you look at some of the conclusions in the basin study, and I want to frame a little bit Robert's reaction to this horrendous 3.2 million acre foot gap that is projected, which is, it's important, I think, to note that there's some 114 different climate projections that are in the study. The 3.2 million acre feet is the median of those 114, so that means that half of them are above and half of them are below. The demand that was projected in that study is, for the most part, projected outside of the basin in areas like metropolitan. I'll call Phoenix, Central Arizona, outside the basin, even though it really is. There's importation of water to that portion of the basin, to the Colorado Front Range. And so those aren't really demands within the basin of Colorado River water. Those are demands outside the Colorado River that are assumed to be served by Colorado River water, so therefore there's a shortage. In reality, as Jeff noted, Metropolitan's looking at flat. They're looking at conservation, reuse, different desal, a number of different sources of water. And so it's, I think, a little bit misleading to say that you impose all these external demands on the system and therefore there's a shortage. That having been said, there are clearly going to be gaps. We're seeing that this year with the announcement tomorrow with the Bureau of a 7.48 release, with the levels in Lakes Mead and Powell, with the last 14 years being one of the driest, if not the driest, 14-year period in recorded history. We do need to come together as a basin, upper basin, lower basin, and look at the overall management of the system, the deficits that are there, and how we live within the budget of that system. And as municipal entities, we deal a lot with turf management in terms of grass. We impose drought restrictions on our customers that limit lawn watering. There's a lot of alfalfa grass, as was noted in the basin, and I think that that gives us opportunities to manage that demand in ways in partnership with the agricultural community, in partnership with the environmental community, where we can move water through the system in ways that benefit the environment as well as managing demands in the system. And I think we have significant opportunities as basin states and as utilities to work proactively to achieve those results and manage our way sustainably as a basin into the future.
Great. Thanks. Let me just kick off questions, if I can, with a question for all of you. And I want to, I guess I want to ask you to sort of maybe suspend a little bit of reality right now and think about a world without the Colorado River Compact. I mean, there are a lot of different concerns about the compact. David Getches many years ago wrote an article, I think, in the Colorado Law Review, suggesting that it was based on a mistaken fact, and you could at least argue that it's not enforceable on those grounds. But certainly, in a world where there might be a huge deficit in the amount of water that's available, it's fair to ask whether or not that system still works, and whether we ought to, at least as we're talking, everybody's getting along, that's great. Should we be talking about a different model, a more specifically cooperative model that has us sort of working together to solve our water needs? Any thoughts?
Well, I think that as I talked about with the Arizona versus California decree, is forming the framework for the agreements that have been reached by the states. The compact itself similarly forms a foundation for the states to work together to manage the system in a sustainable way. And I think that's been demonstrated over the last 15 years through a series of agreements that we've reached. The 1968 Act, as Larry noted, specifically contemplates a partnership between reclamation and the basin states in the operation and management of the reservoirs in the system. We have a regular process. It's not an official compact commission. I know David was a proponent of the establishment of a 7-state compact commission, and I had many arguments with him about that. We're really kind of operating in a de facto way where each governor has a representative. The upper basin states have a compact commission with a federal representative, and the major water users and contractors in the lower basin are all at the table and discussing those issues. And they also result in environmental benefits along the way. We have an upper basin recovery program, a lower basin multi-species program. We're talking about management of releases from Glen Canyon Dam for the benefit of the canyon. So the environment is specifically on the table in those discussions. So I think we really divert our attention unnecessarily to talk about, should we do something different with the compact, or we should establish some new governance system to manage it, because right now it's working pretty well, I think.
Well, one of the things we found is, since the mid-90s, Metropolitan's probably got 10, maybe a dozen different programs with different water agency districts, cooperative programs, contracts, where we either fallow land in agricultural districts and take some of their water from year to year. We have banking programs, we have conjunctive use programs, and all these we've done since the 90s when we realized we couldn't go grab another river. All those programs were very difficult to negotiate because everybody was very concerned that they were going to hang on to their rights and not give up something in perpetuity to us when we did that. And that was really the trick in negotiating all those, and people have become more comfortable with them. But you needed that baseline. People had to have that belief that this was theirs, that they could then trade from and work against. And that's what I think the compact provided. Whether or not those are the right numbers, how it was set up, mistake of facts, more water at the beginning, and it at least sets that baseline that we can then work from and do cooperative programs. The idea of trying to move it around or change it and reopen it strikes me as a lot of brain cells that could be used on something more creative.
Since this is a law school, we're trying to find jobs for our future. We see that as an opportunity.
That'll keep them busy.
Yeah, I have to agree with Jim and Jeff on that point. Going back, again, the theme of going back and trying to operate in a different realm. I think the compact was very important in Arizona specifically. I don't think folks put enough attention on how it really was an impetus for water management in Arizona. I don't think many people know that there's water management in Arizona. But there is. Trust me. Ask any of our farmers or our cities, and they'll certainly enlighten you. The Groundwater Management Act, the 1980 Groundwater Management Act, that's a stretch, but I don't think it would have been possible without the compact. The whole issue with the CAP, which really was the impetus for that, the need for water management, for groundwater management in a state that was in parts of the state that were dependent on that supply. It's not a sustainable water supply. So I think the compact had a lot to do with, and was indirectly responsible for that. The Groundwater Management Act has requirements for mandatory water conservation for municipal, industrial, and agricultural water users. The restrictions on expansion of agricultural lands on groundwater. The requirements for a 100-year assured water supply, meaning development has to demonstrate a 100-year water supply before they can sell a lot. Maybe that's a lot to put on the compact, but I see a relationship there. It sort of was the beginning of that structure that led to Arizona's positions and the Arizona v. California, and the need and want for the Central Arizona Project, and then the Colorado River Basin Project Act, and then the threats from the federal government on funding for the CAP. Arizona needed to get its act in order and manage its groundwater supplies, and we've done that. We've taken steps beyond that too in managing, requiring water conservation, drought plans, water supply plans from every community in the state of Arizona. These aren't little things, they're big things, and they lead to reductions in water use, real reductions in water use, quantifiable reductions in water use. We can demonstrate those things. So,
Good. Thanks. Questions, comments from the audience?
Thanks. Can you hear me? All right. I'll actually be speaking about the compact and the relationship between Arizona v. California and the compact tomorrow. I wanted to ask just a general question. It sounds like a common thread through all of your comments is that the compact has served as a baseline for conversations, collaborative oriented conversations in recent years that have resulted in some progressive developments, right? But it seems like at the same time, based on Mr. Kightlinger's comments, that folks do come into negotiations with conceptions of what the compact means, what their entitlements are. And I take from that the fact that there are certain unresolved disagreements as to the meaning of the compact. And I wonder to what extent you think those disagreements might need to be resolved in the future, as opposed to, again, the compact serving as a framework and perhaps folks being able to craft collaborative measures around them without having the meaning of the compact actually fleshed out in a more finalized manner.
Well, of course, there are a number of lingering differences of opinion about what the compact means and what water is included, and that have been well documented through law review articles and discussions between the basin states. And in fact, as we have woven our way through these series of negotiations, many parties bring that. Now, I will include the decree in Arizona versus California and the 1968 and the California priority, among those suite of areas where there's disagreement and problems of potential conflict between the states. And parties that bring that baggage with them into those negotiations. And I think that the success is that we have been able to weave our way around those and end up where everybody still is able to have their position, and yet we accomplished real tangible results. We are going to have to, at some point, potentially in the very near future, given the status of storage in the system, really put those issues to the side and figure out how, in a cross-cutting way, we can put together a series of measures and agreements that will, as I said, sustainably manage the river into the future. And that will be a challenge, but I think that given the history we have, we're going to have to recognize that. We're going to have to recognize the politics that play into all of that, and figure out how we can have a package that accomplishes that result. But it'll be hard. There's no doubt about it.
Comments? One quick question. Comment?
Sandy, this is a question for you. You mentioned real augmentation, and everybody has their own opinion about what's feasible and what's not, so I would love to know what you define as real augmentation.
wet water. We're struggling with, we're not struggling with this right now. We're working through this in state right now, and are working with our partners in our state, and they're working with the other municipal contractors or folks in other state. I think this is in the other lower basin states. And I look at, when I think about augmentation, I'm thinking of new water. The desalinization, weather modification, watershed management. There's no question in Arizona that we aren't facing a crisis regarding the management of our forests and how that is supposed to, or how that was intended to be, how they were intended to be managed. The Tono National Forest is an example. That forest, the reason for that forest being created was for watershed management. We've gotten away from that, which has led to other problems that are huge. Not only in Arizona, Colorado, other western states. I think it's becoming a larger and larger problem across the west and the southeast, and as far as management of our forests. So I look at it as developing new water supplies. I don't necessarily look at it as transferring water from one area to another, which is where you wanted me to go, I think, in some of this. No, I think it's important that we have to look at things from the standpoint of moving, if we're going to move forward, if the state, if California or Arizona or any other state or any other community wants to grow. And that's the first question that you have to ask. You have to ask, do you want to live with what you have, or do you want to go find something else? So there's a lot of work that needs to be done before we talk about that, but we can't wait to talk about it either, because I think the Poseidon plant was the example that you were given, and the CAP was another example that we have given. It took years. These things take a long, long time to get put in place, to finance, to construct, to actually have water move. And so that's when I'm talking about real augmentation, that's primarily what I'm talking about. But I'm also talking about it from the standpoint, and what I've said in public and other places, is it's not just for municipal uses. I think we have to look at augmentation for, or at least look at how we can benefit other users, the environment. We recognize the importance of agriculture in our community. It doesn't cost us much for milk because we grow the alfalfa and the dairy cows right there. So that's a benefit that I have in Arizona, and I enjoy that benefit. So it's just important to recognize that there's multiple users that are in this mix, and that's going to be the big challenge for us. So.
Okay, thanks. It was really great to have the perspective of three people who are dealing with these issues on the ground day to day. It was really helpful to get your perspective on that. Please join me in thanking our panel.